I'm Stephen Kay, QC. I'm Head of Chambers at 9 Bedford Row, London. I'm an international criminal law expert. I've been involved in cases for over 25 years, and I'm an author of this report along with Rupert Boswell of RPC Solicitors. I've been a criminal lawyer for 46 years, and in that time, the concept of justice has become a very important matter in my life. And if I see injustice, or I believe that the narrative that is being brought against someone is flawed and wrong, I take up the challenge to defend people. The report came about because I was hired to consider the Lundin case, and I noticed that there were issues arising that I had seen before in other international criminal cases. And I was very concerned by what I had seen, and I felt that it needed to be examined carefully and to understand exactly what the basis of the allegations had been against the company that caused the investigation. Let me make it clear. This report is the result of the analysis and research of my team and Rupert Boswell of RPC Solicitors. It is our view, it's our research and analysis upon materials that have been very important in relation to the prosecutor's case. When a report like ours comes out that challenges the prevailing narrative supplied by others, and the narrative of the NGOs was relying upon recycled information, one between the other, and the information that they put together relied on a very narrow band of people and influencers. And I think a reader looking at our report should look at it with the kind of mind that challenges that narrative. It's very important once a narrative is established that we don't believe that the narrative is the truth. The truth is the evidence and the facts. The conflict in Sudan had been ongoing for many years. This was a state that had been forged by the colonial past, the British. It had collected together a large number of disparate peoples and tribes and put them on a map together. And those tribes had had ongoing conflicts between themselves for many, many years. The conflicts concerned land, it concerned resources, it concerned revenge, it concerned political difficulties between them. And so at that time, the state of Sudan was still a state that was trying to forge its own identity. And when the KPA was signed, it was viewed that there was going to be a referendum on whether southern Sudan was entitled to split off into a separate state and become South Sudan. And so there were competing interests in relation to the control of assets and resources. There was no reason why Lundin shouldn't set up operations in Sudan. This was a country that had just entered a peace agreement that had brought a number of the warring factions together. There was an atmosphere at the time of constructive engagement. It was decided at EU, UN level that such operations were a benefit to the states that had natural resources, to help them exploit them, to help them develop their economies, get off the aid budgets that the UN and EU were pouring into them. It was a reasonable commercial decision to make. 14 or so oil companies took the same decision. Complicity, in international law terms, would require intent. It is ridiculous to think that a properly run company would intend to harm civilians. Civilians that it was providing facilities for, medical facilities, education, sanitation, water, encouraging agriculture, using the local population as it had to under its agreement for local labour, under the agreement between the government and the consortium Lundin were within. One of the matters that interested me about this case was this. In 1997 to 2003, there were 235 exploratory and appraisal oil wells drilled in the whole massive oil region of southern Sudan. Lundin drilled only 4 of those. In that 6 years, Lundin had only been working for 3 months of the year, 23% of the time, I think the equation works out. It seemed to me, why this company? There are many other companies, 14 or so. Why this company that's had such a small presence on the soil of Sudan? Why would it have been responsible for oil wars? It doesn't make sense. And if you look at it, there was a case that failed in the US against the Talisman Oil Company in a neighbouring block, Block 4. Lundin were in Block 5A. That was a Canadian company. It's a case brought in the US, and there was a claim, a civil claim, made by the South Sudanese churches and a couple of political individuals that they had been the subject of harm caused by the oil company as a result of the acts of the government of Sudan. That case was dismissed by the American courts and the appeal court on the basis that there was no connection with the allegations that were being made as to the acts of the government of Sudan. There was no connection with the Talisman Oil Company. So that struck me as thinking, well, they've brought this case, which was supported by the European group ECOS, who have filed one of the reports, Unpaid Debt. They brought this case against Talisman, failed, and then turned to bring one against Lundin. Why Lundin? Well, because of Sweden's perhaps liberal and very distinct rules upon universal jurisdiction was seen as being a soft target. And in those circumstances, one questions what is going on here. It was another factor that caused me to suspect that this case was not being brought on good evidence and in good faith. And that's because there had been forum shopping. So we've got the delay. It's 20 years ago. People at the time, 20 years ago, had gone out to Sudan, EU ambassadors, the World Bank, for instance, and all of them had said that the allegations being made, they did not see any evidence in support. And so it seemed to me that this was legal activism at work, if you like. These are people with the objective of targeting an oil company to bring a prosecution. The political background behind bringing this case is a very interesting story and is part of the story of the delay. Because at the time when Christian Aid's report came out in 2001, the whole issue was raised in Sweden. It was raised at a political level by Anna Lindh, the foreign minister. There were inquiries and explanations required. Lundin immediately did its own investigation upon the allegations that were being made and sent out the head of corporate responsibility to check the allegations, check the facts for herself on the ground, along with a very distinguished European diplomat, Carl Bildt, who had been involved in the Balkans and was one of the leading figures in the Balkan peace solutions of the 90s. So they went out and they found that there had been no credence in the allegations. And the report was filed by the head of corporate responsibility that rebutted the allegations line by line. Nothing was left unanswered. And it seemed to me that the noise was actually then being made on the political level by particular parties who were targeting Carl Bildt as well as targeting Lundin. And so the story continues at various episodes of political convenience over the next 10 years to suit the interests of the Red-Green Party. And then the prosecutor makes a decision 3 months before the election to undertake an investigation. And then another 10 years passes. That doesn't seem to me to be a history of a case that passes normal review. A case running like that needs to be questioned and looked at carefully as to, well, why wasn't there a prosecution at the time? If the evidence was there, why does it make it? It's not a case where there's better evidence 20 years later or 10 years later. If the facts and the allegations were true and correct, the evidence would have been there at the time. Well, why wasn't it collected to bring a case? The reason being, I believe, was that there were real doubts at the time about the nature of the allegation. The NGO reports are not constructed and written as if they were reports upon which a legal case would be based. The production of those reports do not involve collection of evidence in a way that is fit for purpose for a court or a trial. The reports themselves are alarms or alerts, if you like, that there are issues that are happening in a community or in a place that involve conflict and harm. But the collection of the evidence and what is behind, what is the story behind that conflict is something that requires a very careful preparation if it's to be used in a courtroom. In international cases, such reports by NGOs are not admissible as evidence to prove any particular evidential point. Now, the problem with the Sudan reports is that they were prepared, having been given access to the region by one side, the SPLM or SPLA. So they were reports that were constructed based upon a control over what was seen, what was said, and what was done by the party and side that was in conflict with the government of Sudan. So the sources being relied upon had to be checked if they were going to be relied upon as the truth and having credibility. The sources of information for the NGO reports, to a very large degree, were based upon those involved in the conflict from a particular side. One of them, Peter Gadde, was a notorious militia leader who switched sides between one group and another so readily that no one really knew whose side he was on. He was providing the background facts and information to the NGO reports when he was himself involved in the conflict, when he was himself involved in targeting civilians. That kind of structure of a case is liable to have a flaw in its construction. Why weren't these matters raised in those reports? Why didn't the authors of the report say, well, we're relying here upon information by a particular individual who's accused of war crimes. It's not sure which side he's upon, and he is someone who is targeting the civilians of other groups, other factions. Why wasn't that put into the reports that were targeting either the oil companies or particularly Lundin? The reason was it would have undermined the narrative and credibility of the report at the time. Generally, a case takes a long while to investigate because the prosecutor or those investigating the case are trying to find the evidence. And if there's an absence of evidence, it takes a longer time and, in fact, becomes impossible to actually produce a case. So over 10 years of investigation against a particular target, and the target was Lundin, has taken too long, in my view, to be a reasonable time by which a prosecutor should have defined his case. These processes require a prosecutor to have control on the ground. No case should be brought by a prosecutor through intermediaries. Intermediaries are those people that supply the witnesses, they supply the facts, they control the prosecutor, if you like. It's not good enough for a prosecutor to say, oh, I do my duty sitting back here on what is brought to me. If you do your duty in that way, how do you know what you are being brought is correct? Now, the lesson learnt by the international criminal courts is that those cases that succeed are those whereby the prosecutor has had control over his own evidence. The cases that have failed have been those cases whereby the prosecutor relied upon intermediaries, others to populate his thought process, others to direct him to witnesses, others to supply him with their case theory. A prosecutor should have his own case theory. I've been dealing with international war crimes cases for 25 years. I was in the first case that the Yugoslavia Tribunal tried the case of Tardich. And I recently completed the Kenyatta case at the ICC. I have noticed that all the cases that I have been involved in, as well as other cases that enter these institutions, that there is a strong political element. These cases are often not about someone doing X or Y. These cases come about because of a political context. In my view, the prosecutor should step back, look at his evidence from a distance, completely coolly, and without in his mind the representations and pressure that inevitably come about in a case such as this. These types of cases attract a pressure, a political pressure, a pressure from those making representations on behalf of others. And he should look carefully as to whether his case has the evidence that proves what he claims in his suspicion sheet. Quite frankly, a review of that evidence would be a process that he could take in a very short period of time. And in my judgment, this case will be found as lacking evidence.